Good morning. Can y'all hear us?
Yes, sir. I can see and hear you. I'm just getting the online courtroom fired up. I'll be with you in just a moment, okay?
There, Your Honor.
All right. All right, good morning. Welcome to the 294th District Court. I am Judge Chris Martin. Please today remember, if you are in the courtroom, if you're appearing in the courtroom, to maintain social distancing, wear a mask if you want. If you need one, do not have one, let the court staff know and we'll provide you one. In a moment, I'm going to call names. If you are here, I need you to raise your hand and say present or here so that I can acknowledge you for the docket. Jacob Howell. Thank you, Mr. Howell. Justin Devine. Mr. Ashmore here. Mr. Devine has contacted the office and indicated that he may be running late due to a flat tire. We'll give him some time to make an appearance. Jeremy Hendricks. Here.
Your Honor, counsel present is via Zoom.
Thank you, Mr. Harrison. Cruz Martinez. 10:30 for Mr. Hyde. And what about Mr. Martinez? From where though? Does he say like when he expects to be here? Ronald Keene. Ronald Dean Keene.
Judge, I believe Mr. Manning is in the hall speaking with Mr. Keene. He told me he was here.
Okay, thank you, Ms. Heisman. Kenneth Stanley. Kenneth Ray Stanley. Christopher Vanderlinden. Thank you, Mr. Merleader. Jonathan Kaufman. Thank you, Mr. Knoll. Anthony Michael Davis. Here. Thank you, sir. Tristan Lane. Here. Brittany Alviso. And Ms. Alviso, I'm going to have you report to pretrial release at this time just to complete some paperwork, and then I'll recall your case. And Mr. White, I'm having Ms. Alviso sign her conditions of pretrial release.
All right, Judge.
Scott Bowden. Nicholas Fincher. Marcus Fowler. Ivan Rostro Garcia.
Your Honor, I wind up getting a text message from Mr. Garcia yesterday stating that he has taken he's now tested for COVID. Told him he would need to send in the results so that I could show the court that he was actually in quarantine at this point.
Okay.
But I'm not at my office to be able to get that to you right now.
Can he join us via Zoom, Mr. White? Or do you know?
I have no clue.
Do you know if he has a smartphone or a telephone?
I have to assume he has a telephone.
Can you have your office make contact with him and see if he can appear via Zoom, and we can walk him through how to do that if he has a telephone?
I will do that whenever I guess we're through calling.
Okay. And if he's, medically unavailable as far as doesn't feel well enough, then I'll need that information. But if it's just he's been exposed and he's in quarantine, then maybe we can work around that.
All righty.
Mitchell Autry. Mr. Autry is appearing via Zoom. He's present. Willie Jopling. Katrina Lambright. I thought that was set today for. All right, I'll have to go back and look in just a moment. Dustin Sorrells. Daniel Garcia is appearing via Zoom in the custody of Galveston County. Blake Egret. Blake Austin Egret. Mr. Harrison, are you ready on Mr. Hendricks?
We're ready for an announcement, Your Honor.
All right, Mr. Hendricks, if you'll make your way to the podium. This is cause number CR 20-81, State versus Jeremy Ryan Hendricks. Court shows that we are set for status today on plea. Is that correct, Mr. Harrison?
That's correct, Your Honor. Ms. Curry and I have spoken very frequently about Mr. Hendricks' case as recently as last evening. I thought at our last hearing, and I frankly think Ms. Curry thought that we were pretty close to having a resolution worked out. I still think we're close. A few things have developed since then that we're working through. When I spoke to Ms. Curry last night, she said she was not prepared to go forward with the plea that we had reached previously today, but asked if we could set this off a little further. Mr. Hendricks is in a anger management class. He is scheduled to complete that on November 8th. That's his last session. And if the court would indulge us and could allow us to come back for either a status or a plea hearing sometime shortly thereafter, I think we're going to have it worked out.
Any objections?
No, Your Honor.
Are you available on November 12th, Mr. Harrison?
Check. What time, Your Honor?
At 9 a.m.
I'm scheduled for a Zoom in the 114th here, but
Do you anticipate that announcement taking more than an hour or so?
no, Your Honor.
Then we can just set it for 9, and then your client can be here, and then you can zoom in when you get a chance.
Yes, sir.
Okay, court will set this for status on plea at 9 a.m. on Thursday, November 12th.
And Your Honor, if we have it worked out prior to that day, we'll get the plea papers turned in before the 13th, before the 12th.
That'd be good. All right, we're going to have your client sign his notice of setting. Mr. Hendricks, you're free to go. We'll see you back on November 12th at 9 a.m.
Yes, Your Honor. Thank you very much.
You're welcome.
Thank you, Your Honor.
Anything further, Mr. Harrison?
No, sir. Thank you.
Bet. Have a great day.
Good to see you via Zoom.
Good to see you. All right, court's going to take Mr. Gonzalez. I'm sorry, Mr. Garcia. Give me just one moment, Mr. Garcia. right, this is cause number CR 20-79, State versus Daniel Ray Garcia. We are set today for arraignment on unlawful possession of firearm by a felon. Mr. Garcia is appearing via Zoom today in the custody of Galveston County. Mr. Garcia, were you able to get your charges there, your business there in Galveston County resolved?
No, no, sir. They had a trial going on. It was the first trial that they set up for the court, the 56th district. They did postpone my disposition for 12 days, which would be on the 19th now. So we're 6 days away from our second disposition here. So my lawyer said that we should be able to take care of it here on this on the 19th, which is 6 days away now.
Mr. Garcia, have you asked for a trial in Galveston County, or are you trying to resolve it via plea bargain? I don't want to hear what the details are. I just want to know.
Yes, sir.
Yeah,
we're ready to plea bargain on it. I should get time served on this.
Okay. Stay any position on Mr. Garcia. So at this point, the court can either appoint. Mr. Garcia has indicated to the court in previous hearings that he believes he'll have the financial ability to hire an attorney to represent him. He is obviously in Galveston County. The court could arraign him today. The court could appoint him counsel, or you can request a bench warrant, or we can reset and see if Mr. Garcia gets his business resolved.
Judge, we have no objection to resetting Mr. Garcia. If he believes he has the financial means to hire an attorney, then I don't see the need to go ahead and appoint him one today. We'll give him the opportunity to get his business in order there.
Mr. Garcia, is all of the things I stated still true?
Okay. Yes, sir.
Are they still true? You still believe you have you will have the ability to hire an attorney to represent you on these charges here in Van Zandt once you're out of Galveston County?
Yes, sir.
Okay.
As soon as I'm released, I can start going back to work.
All right, then what we'll do is we'll set you for arraignment on November 12th. You said that you anticipate October 19th being your next court date in Galveston County. Is that right?
Yes, sir.
Then I'm going to set you for 9 a.m. on Thursday, November 12th.
Okay, thank you, sir.
I'll have my staff send a notice down to Galveston County to put with your papers. That way you get released, okay?
Okay, thank you, sir.
All right, so we'll see you again on Thursday, November 12th at 9 a.m. If you make bond or you resolve your case before that time and they release you, then you're to appear in person here in Van Zandt County at the courthouse by 9 a.m. on the 12th. Okay?
Thank you, Judge Martin. Have a good day.
Thank you. I appreciate yes, absolutely. I appreciate you gentlemen working with us this morning on this.
Yes, sir. Anytime, Your Honor. Have a good day.
You too. Is Mr. White in here, Nolan White? No? Okay. I was going to take up Mr. Autry. So, counsel, do we have anyone that's ready? Mr. Schmidt? Who are you ready on? Mr. Lane? This is CR 18-368-435-436, CR 2014. State versus Tristan Craig Lane. We're set for docket call today. Mr. Schmidt, go ahead.
That's correct, Your Honor.
Judge, I'm going to travel. We can set it up. It's much.
Any opinion, state?
No, Your Honor. I would ask for no more than 60 days, but up to that, we'd be okay with
you think it'll take us 60 days to decide whether there's going to be a resolution?
It's either have their results or downstairs.
All right, court will set. Are you available on December 8th? All right, court will set Mr. Lane for Tuesday, December 8th at 9 a.m. Yes, sir. Any other counsel ready? Thank you, sir. Mr. White, are you ready on any of your, Mr. Jeff White, are you ready on any of your clients?
Yes, sir. I'll attempt to be.
Well, it's okay. Just need to know.
On Alviso,
Ms. Alviso, you'll make your way to the podium, please. This is CR 2100, State versus Brittany Nicole Alviso. I believe we're set for pretrial today, Mr. White.
that's correct, Your Honor. I filed my 3 motions that I typically file. I don't believe the state has any opposition to any of them.
Are any of those contested motions?
Never have been before, Your Honor.
Okay,
They're a discovery motion and the 3 that I'm sure you're familiar with that I file every time.
State.
Judge, we have not reviewed the particular motions in this cause, but we have no objection at this time to any of those. I don't know if we've received, I don't see them in our system. I don't know if we have received copies of those, but if they're his motion for discovery, his motion for leave to file new motions, and I'm not sure what the other one would be. If they're his typical motions, we would have no objection.
They are the same ones I file every time, Judge.
Okay. All right. There being no objection to the motion by the state, then the court will grant defense motions. Finding there are no contested motions, the court will set Ms. Alviso for docket call. Are you available on Thursday, the 12th, Mr. White?
November the 12th?
November the 12th, yes, sir.
I believe so. That's a Thursday?
That is a Thursday.
Yes, sir. I'll be available.
All right. Court will set Ms. Alviso then for Thursday, November 12th at 9 a.m. for a docket call. And Mr. White, Ms. Alviso has signed her conditions of pretrial release and has been provided a copy of this.
Okay, thank you.
All right, you're free to go. Mr. White, ready on anyone else?
Anyone you want to call, Judge, except for Garcia. I'll be calling him as soon as we'll get these others done.
Scott Bowden, CR 2103. All right, Mr. Bowden is also set for pretrial, Mr. White. Any contested pretrial motions?
No, Your Honor. Same 3 motions that I've filed before.
Same position by the state.
Yes, Your Honor.
There being no objection to Mr. White's motions, the court will grant those and will, finding that there are no contested pretrial motions, sets Mr. Bowden for November 12th for docket call at 9 a.m. Mr. Bowden, once you sign your condition here, once you sign your notice of pretrial reset here, then you'll be free to go. Okay. And the bailiff's going to bring it to you. No, you stay right there. Yeah, the bailiff's going to bring it to you. She's filling it out. Once you sign that, we'll give you a copy. You'll be free to go.
So we probably should-
Nicholas Fincher, CR 20118. Mr. Fincher is set for docket call today, Mr. White.
Your Honor, I'm going to make an announcement. I'm not ready. I believe that we could have one more month of negotiation. I believe that this would probably be resolved next docket on the 12th.
Any position by the state?
No objection, Your Honor, because Mr. White is quarantined. I've been unable to talk to him about his cases. I also believe that this is a case that could be worked out.
All right, court will reset Mr. Fincher for docket call on Thursday, November 12th at 9 a.m. Mr. Fincher, once you sign your notice of appearance and receive your yellow copy, you're free to go.
Thank you, Your Honor.
Mr. White, before I call Mr. Fowler, the court's inquiring about a delinquency on his pretrial release. So I'm inquiring about that right now with pretrial services. So it'll be just a moment, and I'll call him. Okay.
All right, Judge.
Mr. Knoll, are you ready? Mr. Kaufman, CR 2075. Mr. Kaufman set for docket call today, Mr. Knoll. Do you require Mr. Kaufman to sign anything to review his discovery? Mr. Kaufman, have you reviewed the discovery in your case?
No, I have not.
Do you intend to review the discovery in your case?
Yes, I'm currently trying to hire an attorney. I should have one like next week.
Well, that's not an issue before the court right now. The issue is you are appointed Mr. Knoll because you requested a court-appointed attorney. The court found you to be indigent, appointed Mr. Knoll to represent you. He's reviewed the discovery. He's indicated to the court that he's attempted to review that with you. And the court today is expecting you to either say that you're going to reach a plea bargain or you're going to request a trial. The issue of whether or not you hire an attorney, there's no motion to substitute counsel at this time.
I'm requesting a trial.
You've already requested an attorney and you have one.
I said I'm requesting a trial.
And you want to go to trial without having reviewed any of the evidence against you.
No, I'm hiring an attorney to review it.
You have an attorney.
He's not, me and him don't see eye to eye. Me and him don't even get along. The last time I talked to him, he cussed me out and everything. So I don't want to talk to him.
So, Mr. Coffin, you want to go to trial without reviewing your discovery, without reviewing the evidence against you.
No, I want to review it, but I want to review it with somebody that has my best interest.
Well, how come you haven't hired that attorney that you believe is going to have your best interest at heart more so than Mr. Knoll?
Because when I got incarcerated, I lost my job. But I have just now gotten a job, and I'm gonna hire me an attorney.
So you've got no money, right?
Right.
And attorneys don't work for free, right?
Right.
So you're indigent.
Right.
So you've requested a court-appointed attorney, and here we are, right back at the beginning. Here's Mr. Knoll.
I'm still not gonna get nobody that's gonna railroad me.
Is there a plea offer on the table from the state?
There is, Your Honor, there's a plea offer. Would you like to hear?
Yes.
Of 12 on the second-degree drug case to resolve both cases.
So, Mr. Coffin, what would you have the court do today for you? What would you have me do?
I'm not understanding what you're asking.
Well, I told you that today is the day that I expect you to either tell me you're reaching a plea agreement to resolve your case or you're requesting a trial. And you have said repeatedly that you're going to hire an attorney that has your best interest and someone who's not going to railroad you. And I've told you that why haven't you already hired that person? And you said, I've got no job. I've got no money.
I said I lost my job. I currently got a job now.
So what would you have me do today? Just keep on resetting it until you get a job?
No, I have a job now. That's what
Okay.
I'm saying.
So how long is it going to take you to hire an attorney?
I told you I should have an attorney by the end of this week.
By the end of this week. This is what we're going to do. I'm going to set you for, based on Mr. Knoll's statement that you've refused to review your discovery. The court is going to set you for jury selection beginning on October 26th. And if you hire an attorney by the end of this week, then that attorney will know what to do.
Okay.
Okay. So the bailiff's going to bring you a notice of setting you for jury selection on October 26th. You're to appear in the courthouse basement downstairs, and you'll be greeted by a staff member with the court who will give you more information on that day. Mr. Knoll, your attorney, is not going to be required to be here unless he receives notification from the court that the case is set for trial.
Yes, sir.
And are you encouraging your client to review those before trial? And are you doing so again today on the record? And do you believe that it would further assist him in preparing a defense for his case if he were to speak with you about his perception of the facts and evidence that he may be able to bring in his own case? Mr. Kaufman, I also show that you are delinquent in paying for your court-appointed attorney. The court has conditioned your bail in this case, that you report, and that you pay reimbursement to Van Zandt County for this court-appointed attorney that you requested and received. I show that you are currently delinquent $150, and you're also delinquent $30 on your pretrial release payments. Why shouldn't I revoke your bail today and just put you back in jail?
Because I'm trying. I come to all my court appearances. Every time they tell me to report up here, I report. I take it on my bills, but I'm doing everything I'm supposed to do. I'm just struggling right now. But I'm trying.
Can you make a payment today?
I can.
How much can you pay?
Probably about like $30, $40, $50.
How much?
Like $30, $40, or $50.
I said one more time.
Like $30, $40, or $50.
30, 40, or $50. All right, then I'm going to order you to report to pretrial services and make a payment today. Okay? All right. You're free to go. Sure, sure. Okay, you'll bring me that waiver. Are you available on the 12th, November 12th? That's fine. If you ever need more time, just call and let us know. Mr. Davis, Anthony Michael Davis, CR 20111. Mr. Davis, you are set for arraignment today. Your attorney has submitted the waiver of arraignment and acknowledgement of pretrial hearing. I'm setting your case for pretrial hearing on Thursday, November 12th at 9 a.m. Once you receive that once you sign that white copy and receive the yellow copy, you'll be free to go. Just one moment. Let me get him situated. All right, Mr. Jeff White, are you ready?
Yes, Your Honor.
Okay, let's go ahead and take up your last case. CR 2159160, State versus Marcus Anthony Fowler. All right, Mr. Fowler is set for pretrial today, Mr. White.
Your Honor, I have yet to receive any of the discovery, so I have not filed any of the motions that I normally will file. I feel certain that the state will not have any opposition to them at that point. So if the court wants to move the case along further than the normal pretrial, I wouldn't have a problem. But I haven't seen anything yet on the website.
Your Honor, we did not have Mr. White down as the attorney of record on these cases. I'm sending him the discovery via the portal right now. Because of that, we would not be opposed to another pretrial to allow Mr. White to get that and review that discovery.
And that very well could have been my fault. I may have inadvertently not given him the given the DA's office a copy of my letter of representation. I wouldn't be surprised if it wasn't the case. So it's probably my fault.
All right, the court will set Mr. Fowler then for pretrial on Thursday, November 12th at 9 a.m.
Thank you, Judge.
You're welcome. And Mr. White, there's an issue that concerns me regarding Mr. Fowler. I show that he is delinquent on his pretrial release supervision fees. And is that amount correct? It's $920. And I'm going to let him sign. We're going to discuss that. Mr. Fowler, I need you to take that toothpick out of your mouth. Think it's funny? No. Well, you're smiling and laughing. Mr. Fowler, I show that you're delinquent almost $1,000 in your pretrial supervision fees.
Yeah, where's Carl Waddell? He hasn't told me nothing. I've done everything he's told me.
Have you paid the fees that came on your
I
conditions?
just got to receive this today.
You just received your conditions of pretrial release
I
today?
meant to ever deal. He took my own money, flew to see him on a monthly basis. He hasn't. I just noticed this today. I just saw him a while ago.
Go ahead and have a seat, and I'll call you back up in just a moment.
Yes, sir.
You may. Get this on the record off. Ms. Melantree, are you ready?
Yeah, my client is not. I tried to call this all, and he said, well, even retrial. Also, I spoke to Ms. Burns. He's on page 2. Spoke to Ms. Burns, and she said, on January. We're doing the month of January 2020. He's not coming in. The numbers that I called is not good. So I've tried about 3 numbers.
This is Mr. Stanley, correct?
Yes, sir.
All right, free to go.
Thank you, sir. Have a great day.
You too. Mr. White, are you ready on Mr. Autry?
Yes, sir.
This is CR 2101, State versus Mitchell Autry. And for the record again, Mr. Autry is appearing via Zoom today. Mr. White, I show that we are set for pretrial.
Yes, sir, we're set for pretrial. I don't have any at this point additional pretrial motions to file. I understand. Recovery order at this time. Receive recovery from the state. I would ask for consent.
All right, court will set Mr. Autry then for docket call on Thursday, November 12th at 9 a.m. The only other issue that we need to address on Mr. Autry is, I've got a note that he has not signed his pretrial release papers that has been ordered on his bail. So we may forward those to you and have you discuss that with Mr. Autry, get him to sign that and return to the court.
There is a possibility that this case may be out as well. So it might be moved
Okay.
at that point.
If not, then I'll have a note for us to do it on the 12th. All right, Mr. Autry, did you hear everything that your attorney said?
Yes, sir. Yes, Your Honor.
Okay. All right. So we'll see you on November 12th at 9 a.m. and you're free to go.
Thank you, Your Honor.
You're welcome.
Thank you.
All right, Mr. White, ready on anyone else?
Mr. Sorrell.
Dustin Sorrells, CR 2090. Mr. Sorrells to the podium. We're set for pretrial today.
Your Honor, that's my understanding to be operating discovery order. I believe I've seen nothing from the state at this time. I don't have any additional pretrial motions to file. Docket call.
All right, court will set Mr. Sorrells then for November 12th at 9 a.m. Once you sign your notice of setting, you're free to go. You ready on Mr. Joplin?
Yes, sir.
Willie Joplin, CR 2052. Mr. Joplin's also set for pretrial today.
Yes, sir. I'm in the process of still conducting my investigation on this and trying to get some additional information. I feel like that I will be able to.
What are you lacking in discovery?
It's not discovery, Your Honor.
Oh, it's not.
No, sir.
Okay.
I'm trying to get some additional information.
All right, court will set Mr. Joplin then for docket call on November 12th at 9 a.m. Mr. Joplin, once you receive your yellow copy, you're free to go.
Step out. That's okay.
Here, and we need those white copies.
I'm going to take pictures of them.
Okay, cool.
I'll bring them back.
Mr. White?
Mr. Howell here. Mr. Adams, are you ready? CR 283, State versus Jacob David Howell, set for pretrial.
Yes, Your Honor.
So he wants to move past docket call at this time, not requesting additional time for docket call. Just go ahead and reject the offer and request a trial.
I'm not going to say on the record.
Okay. What the court's standard policy is once we get to pretrial, if there's no contested pretrials, then we move to docket call. Gives time the defense and the state to work that out between pretrial and docket call. And on that docket call date, I would be looking for an announcement of either a plea or a request for trial. Are you available on November 12th? That's a Thursday. Yes, sir. All right, court will set Mr. Howell then for docket call on November 12th at 9 a.m. He'll get the yellow, we'll get the white. Mr. Howell, you're free to go. We'll see you back on the 12th.
Thank you. I think that's all out on the court's now.
Yes, sir. Thank you. Thank you, sir. Ms. Beasley, are you ready on Mr. Bertram?
Yes, sir.
That's going to require some testimony, is it not? Well, okay, I'll call that in just a moment. I just wanted to check with you. In state, I have the physician holding in the waiting room. So let me know when you're ready for that as well. He has treatment team. Ms. Beasley, Ms. Heisel, Ms. Tabraham has informed me that the witness in Mr. Bertram's case will be unavailable in about 7 or 8 minutes, and begin his rounds, I guess, at 10 o'clock. We want to see if we can schedule it later this morning with the doctor, or
That is an option, Your Honor. I would highly prefer that, but I can get it together if we can't.
let me bring him in and let's just inquire as to his schedule and see what we can. Ms. Beasley, is this the only case you have today?
Yes, Your Honor.
I don't even have him on the docket. He's charged with stalking.
Some secret. He's trying to protect her. So he did vacation.
Okay.
Dr. Chava, are you there?
Yes, I'm here.
Okay, good morning. How are you?
I have to leave in another 5 minutes. I was waiting for this call since 9 a.m. I have a treatment team at 10 a.m.
I understand, yes. And what we're going to do at this time is we were just going to inquire as to your schedule. What does treatment 10 at 10 a.m. mean, and how long would you be unavailable?
Oh, my treatment team is when I meet with social workers, my nurse, and my patients, and that will take me about anywhere from 3 to 4 hours.
You start that at 10 a.m., so you wouldn't be finalized until this afternoon?
Yes.
Yes,
go
ahead.
Which is why I have moved it to 10 a.m. because I received an email that I will be having a court hearing at 9 a.m. today.
Well, it was set as well as about 30 other cases. So you're the only one that requires testimony. So we've moved those other cases. So all right, just
Sure.
do me a favor and hold for just a moment. Let me inquire with the attorneys as to what they would like to do.
Yep.
And Dr. Chava, would you be available later this afternoon?
How long should this take? Does this not happen in just a few minutes, or is it going to take longer?
Well, I don't know what the attorneys are going to ask and how long that's going to go. I would say at least 30 minutes minimum, I would think.
Oh, may I know your name and your role in the courtroom, please?
Yes, my name is Judge Chris Martin, and I'm the judge.
Oh, I'm talking to the judge. Sorry.
Yes. Yeah, it's okay. And you're appearing in the courtroom on the record.
Okay. I should be available in the afternoon. If this is going to take 30 minutes, then I should be available. I thought it should take, it should not take that long. But yeah.
Dr. Chava, it may not take that long, but that's what I would at least plan for. So hang on just one moment for me, okay?
Sure. Mm-hmm.
Dr. Chava?
Yes.
Okay. We don't want to impose on your schedule any more than we already have, but what we would like to do is see if we could have a specific time you would be available this afternoon, and we would begin the hearing right at that time and anticipate it wouldn't take more than 30 minutes to get you past your treatment.
So I should be done with the treatment team at 2 o'clock, and I have another meeting for the med staff meeting. Are you guys available at 4 p.m.?
The attorneys are talking. One moment.
Mm-hmm. Or at 2 p.m. I can squeeze this in at 2 p.m.
Okay, then Dr. Chava, we will, if you call back in, and I'll have my staff provide you the Zoom number. When you call back in, I will begin the hearing promptly at 2 p.m. and we'll get you finalized.
2 p.m.?
2 p.m., yes, ma'am.
Okay, we'll do that.
Thank you so much. I appreciate your patience and your flexibility with us. Sorry that it didn't happen right at 9. There was more than just this hearing on the docket, so I tried to resolve a bunch of the agreed stuff.
Sure.
The testimony. So apologize for that, but I'll go ahead and let you go, and just my staff will provide you the info for 2 p.m. Okay?
So am I going to receive an email with that information to
yes,
join the call at 2 p.m.?
Yes, ma'am, you will.
All right. Thank you, Judge. I will join at 2 p.m. Mm-hmm.
Great. Thank you, Dr. Chapa. We appreciate it. We'll see you at 2.
Sure. See you. Bye-bye.
Mr. White, are you ready? Ms. Lambright, if you'll come to the podium, please. This is cause number CR 2175176, State versus Katrina Rochelle Lambright. And I believe we're set for pretrial today, Mr. White.
Yes, sir, we are. I don't have any additional pretrial motions at this time. I received discovery that they have been just they found any additional motions. That's important to say. Not all.
All right, court sets Ms. Lambright for docket call on Thursday, November 12th at 9 a.m. And Ms. Lambright, once you sign the notice of setting that Mr. White's going to provide you and you receive your yellow copy, then I'm going to direct you to report to the pretrial release department. You'll need to sign your conditions of pretrial release papers. And Mr. White can give you more information about that. that all you have?
Your Honor, the court would like to take up on 130 matters.
Your jail cases?
Yes, sir. We got, I talked to the state about rights. We've got waiting on the guidance on a possible charge. In that case, the subject of.
Is he aware?
I'm gonna go out and talk to him today. As far as talking to him about what was gonna happen today, I told him that we could discuss further, that it might be.
My only concern would be is that he knows that the court has said him, that we've spoken, and that it's been your request to have the case reset. I don't want him to think that he's not being brought to court.
I just didn't know if you were having to make a special trip out there one case, which you find or whatever. I didn't want that to occur.
No, and I'm fine with the agreed reset so long as
I'm satisfied with what I've been seeing. If he's not, I'll have him sign the reset out there. And if he's not okay, I'll bring it back.
okay.
Is that okay?
That's fine. What about Mr. Pickett? I see he's
Yes,
with Tarrant County.
yes, sir, he's still in Tarrant County. I spoke with his lawyer there again, Ms. Taylor. They are awaiting what has been termed to me as a full psychological workup in preparation of an open plea. I had discussed a possible resolution. Ms. Heisel, I think she's going to talk to Mr. Cox, or I'll talk to Mr. Cox myself. I've got an idea. I'll probably put it with the court first. If the state's okay with it, they probably would also be driving to Fort Worth and having him sign the plea papers. Talking with Ms. Taylor, they are set up from the jail. He could log in after he'd already signed it. And we would, of course, amend it, but that might be the best way of this situation.
So you anticipate a plea in his case?
I'm very, very hopeful. That's what I don't think. Given the severity of the charge that he's facing in Tarrant County, I figured this would be out.
When would you, in hopes of that, how long do you think?
No, because if we just said it for the can't have everything. We did that, at least just for status, so I can tell the court, we were able to do it or not. Because, my concern is I know this is, if we're not able to come to an agreement, I don't think Tarrant County can come back and get him. And then we're going to be stuck here on our lesser charge, their bigger charge, still out there. But Ms. Taylor's been very good to work with, so I know what the status is of this case.
Okay, so we'll just set Mr. Pickett then, if you'll go ahead and fill out a form. We'll set that for November 12th at 1:30. And on Mr. Rice, how long do we anticipate before we could have indictments, if that's the holdup?
I don't know that, as I understand, my understanding of that new charge, I think it's a little bit of a complicated situation. And I don't know exactly, I haven't talked to Mr. Cox really about what they intend to do on those.
Well, then let's do this. Let's set it for November 12th also.
That,
And we'll do status on new charges.
just have a groundhog day,
We'll have a Groundhog Day.
I will return this after I have to sign this.
Mr. Murray Leader, any update on Mr. Vanderlinden? All right, I'm gonna have his name called this morning, and then I will take that nice under advisement until 1:30. If he doesn't appear promptly at 1:30 at the jail, then of course gonna forfeit his bail. All right, Mr. Fowler, you ready, Mr. White?
Yes, Your Honor.
All right. So, Mr. Fowler, Judge Sandra Plaster issued conditions of pretrial release to you in March of 2020. I have a document here with your signature on it. My records indicate that you reported to the pretrial release department in March or April of 2020, and I show that you've made one payment to the probation department in April of 2020. So what that tells me is that you know very well what's expected of you in these conditions that you signed. Otherwise, you wouldn't know to show up over there. You wouldn't know to pay the $40.
Yeah, there was an issue. I talked to Carlo Dell with the internet deal or something because of COVID thing. He told me don't worry about it. I just talked to him a while ago. He said there was a mistake or something on their part. I just talked to him a while ago.
I understand that, but is there any mistake in the fact that you received?
I tried to do everything I was supposed to do. I did everything he told me to do, sir. So that's all I can do.
Did you call in to pay?
I did everything I was supposed to do. I even told him, there was an issue or something. He said he was supposed to fix it or do whatever he was supposed to and get back with me.
So he told you
that
that
when I saw him the last time, which the last 2 months I haven't saw him, he wasn't there due to whatever the case was.
I understand, but
when I did see him, he said,
okay, hang on. Let me talk for a second. Okay. So he told you that you didn't have to pay the $40. He told you, don't worry about none of that.
Yeah, the last time I saw him, he said he was going to take care of the issue.
The issue of what?
Whatever, because we couldn't do nothing online or something. You'd have to talk with Tim.
All right. Well, I will. Have a seat. We'll all talk with him. All right, Mr. White. We'll get Mr. Waddell in here in just a moment. Try to get to the bottom of this. So what I'm concerned about, Mr. White, is that the conditions of pretrial release were signed, and Judge Placer ordered him to pay $40 a month for his supervision. He signed it, and he's delinquent. So I'm trying to get to the bottom of that. You heard him. He indicated that Mr. Waddell told him he didn't have to worry about any of these things. So we're going to find out about that.
Yes, Your Honor. Yes, I heard him say that.
This looks
All right, Mr. Fowler,
I think.
this is what we're gonna do. Go ahead and just sit back here and speak with pretrial release services. Yeah, go through there. They're gonna get you squared away, and then I'll see you back on November 12th. So once you see them, you're free to go.
So we waived our fine, but this is a state fine. that we-
So they're gonna just meet with him and try to straighten out any confusion they have on his pretrial releases.
So we made ours.
Well, I'll do whatever I can next week to
That's
try
fine.
to help out too.
I think there's some confusion on the department's part, so they're going to straighten that out, and we'll get him squared away. And so I'm not going to see him again today. We'll just see him back on the 12th. Okay.
Okay, thank you, Honor.
Hey,
Just to give you an update on Rostro Garcia, I did get a chance to talk with him. I gave person at his house the phone number to try to get a hold of the court. He's supposed to be sending some information by fax to me and his bail bondsman. And of course, I hadn't seen it. All I know, he was coughing quite a bit. That's about all I can tell you, Judge.
okay. Do you think you anticipate he's going to try to call in or not?
I told him that he could try to do the same thing I had to do, not knowing really how to do this stuff. I've always had someone else set it up for me, but I gave him y'all's phone number, told him that he could get someone to call and they would be able to possibly walk him through it, and that he could be able to use his phone as he evidently doesn't have a computer, I don't think, right now.
Okay, let me do this. Ms. Heisel, I'm sorry to interrupt. Do you have any objection to Mr. Ivan Rostro Garcia? He's charged with state jail felony possession of controlled substance. We're set for pretrial today. You may recall Mr. White's announcement that he was contacted by Mr. Rostro Garcia regarding potential COVID issues. Do you have any objection to his non-appearance today? And we can go ahead and take up the matter of pretrial.
No, Judge, no objection, and I don't know we can go ahead and address the motions, but I would have no objection to resetting for docket call if there's no contested motions.
All right, let's do that, Mr. White, and we'll take that. We'll take the pretrial matter up without him, and you can give him notice of his docket call date.
I'll do that, and I think there's a good possibility we might be able to have this resolved on the 12th. But once again, Judge, the motions that I have filed are the three same motions that I filed in the two previous cases. I don't believe there'll be any opposition to them.
We're not objecting at this time, Your Honor, but we'd like to reserve the right to do so once those have been reviewed.
Okay, so the court will carry those to trial. If one is had, the court will find there's no contested pretrial motions at this time, and the court will set this for docket call on November 12th at 9 a.m. And if you'll ensure that Mr. Garcia receives notice of that hearing.
I certainly will, Judge. And I do believe that, I hope that is my last case. That's the only one I've got left.
I believe that does resolve you, Mr. White. Hey, congratulations on your maiden voyage on the ship we call Zoom.
Okay. Thank you, Judge. I appreciate you.
All right. Have a good
Bye-bye.
day. All right, this is cause number CR 2114-115, State versus Justin Lee Devine. We're set for pretrial today, Mr. Ashmore.
Yes, Judge. And the defense is asking, and the state has agreed to allow this to be reset for a docket call. The court's next available. You have an offer. Actually, we have two offers, which are 9 years TDCJ, no deadly weapon finding on an accident involving death, and a 1245 of the other charge. 8 TDCJ, same offense with a deadly weapon fine, $2,500. $2,500 fine on each of those two plea offers, and Mr. Devine respectfully requests the board reset us for a docket call so we can visit with his family and back ready to make a decision.
All right, there being no contested pretrial motions, the court sets this for docket call on November 12th at 9 a.m. Do you have any scheduling issues on that day, Mr. Ashmore?
I don't think so. May I check my calendar?
All right, November 12th at 9 a.m.
Judge, no reason.
Mr. Devine, I'm going to need you to report to pretrial release today, and I need you to make a payment towards your delinquencies.
Oh, yes, sir.
I show you're delinquent about $180 and that you failed to report in September. So I need you to get with them to clear up those issues.
I didn't know I was ever supposed to report.
Well, you're going to get with them and you're going to discuss that today.
Yes, sir.
You're ordered to report. You need to get, do you have copies of your conditions of pretrial release?
I just got that on my last court date. Yes, sir.
Okay. Then you look on there and it'll tell you that you either report monthly or weekly.
Yes, sir.
All right. So meet with them today, make a payment towards your fees, and we'll see you back on the 12th.
Yes, sir. Thank you.
Is that all you have, Mr. Ashmore?
That's all I have, Judge.
Do you have anything this afternoon? All right. Good to see you.
Strung me out this week. I'll see you. I think I'll see you tomorrow.
See you tomorrow. Mr. Martinez, is Mr. Hyde joining us today?
Goodness gracious, sorry.
Have you called his office? Maybe step out again and call again. Mr. Vanderlyn.
Good to see you.
This is CR 29-3, State versus Christopher Vanderlinden. I believe we were set for status today, and I'm not sure what the status was. Mr. Murleader?
Judge, after announcing that we were announcing ready, Ms. Heisel gave us a plea offer of 60 additional days to do in jail and reduce charge of self-defense violence class A. Mr. Vanderlinden has accepted that plea offer, and if the court has time this afternoon, we can enter a plea of guilty. We're also asking the court, and it's with a fine of an additional $3,500. He's accepted that, and if the court has time this afternoon, we can enter a plea of guilty for that. Mr. Vanderlinden has asked for a report date of October 22nd by 6 p.m.
Judge, it was set today for status regarding Tarrant County, his Tarrant County charge. I've been in contact with the prosecutor over in Tarrant County. He's resolved his issues there. So we have extended that plea offer. Ms. Abney is currently working on paperwork. It's my understanding that Mr. Vanderlinden does not have a vehicle. So if we could get it done before lunch, that might be best for everybody. If not, we will be ready at 1:30 at the jail. And I believe Mr. Vanderlinden has plans to meet us at the jail at 1:30. But for his sake, I would like to try to get it done before we break for lunch.
Is Miss Abney working on it now?
She is. Yeah, she's working on it.
If she's working on it now, then I mean, we have an hour and 15 minutes before lunch, so we can just.
I think we could probably get it done, and then you won't have to figure out how to get out to the jail at 1:30.
And there's an agreement on the report date to execute the sentence?
Yes, Your Honor.
So we'll have that order showing the date?
Yes, and she'll have an order of commitment, I believe, attached to it with that date and time.
Okay. All right. So Mr. Vanderlinden, just have a seat, and then we get the paperwork ready. Mr. Murleader, bring it to you. Mr. Manning, you still working on paperwork?
Just on the final case
Yes, sir.
You are, in fact, Ronald Dean King.
Yes, sir.
And Mr. King, are you a United States citizen?
Yes, sir.
You read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
PTSD.
Are you currently undergoing treatment?
Yes. Yes, sir. Oh.
My court reporter here, she's got to listen to me, she's got to talk to him, and she's got to hear you and talk to him. So are you currently undergoing treatment or on medication for that?
Yes, sir. Both.
And in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation?
Yes, sir.
Feel like you've had sufficient time to review your case with him and all your information?
Yes, sir.
Mr. Manning, can you please reply to your comment? Can you explain to him the legal and constitutional rights? Here's in CR 2128, which Mr. King, you were originally indicted with the third-degree felony offense of assault with a household member by any reference regulation, that there is a plea agreement to resolve your case to that of a class A misdemeanor assault caused bodily injury or pain. And great punishment for that type of charge is confinement in a county jail for a period of
Yes, sir.
that means any plea agreement that you enter into or sentencing that court would have involved in that.
Yes, sir.
In policy number 2020-303, you're charged with information with the class B misdemeanor offense of driving while intoxicated. Alcohol.
Yes, sir. Yes, sir, it is. Guilty. Guilty. Yes, sir. No, sir.
No, Your Honor, we pressed and closed. Your Honor, there is no victim impact statement on file, but we are in compliance with the victim notification.
is sufficient evidence to convict you of this offense, of each offense, and CR 20128, court hereby convicts you of the Class A misdemeanor offense of assault causes bodily injury, family violence. The court assesses the punishment in accordance with the plea agreement, orders you to pay a $2,000 fine, $860 reimbursement fee, $270 in court costs. Court orders you to serve the remainder of your sentence as outlined in the court's order of commitment to jail. Cause number 2020-303. Court finds that there is sufficient evidence to convict you of driving while intoxicated with an open alcoholic container. Court hereby convicts you of that offense, assesses your punishment in accordance with the plea agreement to 46 days in the county jail. Court issues you credit for 1 day of time served. Orders you pay a $100 fine, $270 court costs, and $15 reimbursement. Court orders you to serve the remainder of your sentence as outlined in the times in the court's commitment to jail order.
Your Honor, if I may just put on the record, while we do not have a victim impact statement on file in this cause, we do have an affidavit of non-prosecution from the victim on file in this case.
Thank you, Ms. Heisel. Mr. Manning, can you have Mr. Key print his name on this document here?
Yes, Judge.
Judge, I have something to pass on to you regarding this.
All right, Mr. King,
Okay, okay.
before you leave today, you need to know that on the court's commitment order, all those times that you're to submit yourself to the jail,
Yes,
that you need to show up at the jail with a copy of your driver's license or some kind of photographic ID. Otherwise, they're not going to let you in. And if you fail to appear at any one of those, that could constitute a new charge of escape.
Okay.
You understand that?
Yes, sir.
So your failure to follow the instructions about bringing the ID, they're not going to let you in without an ID.
Okay. I understand.
And your failure to do that and your failure to be incarcerated at the times in accordance with this plea agreement could constitute new charges for you. You need to be aware of that.
I
Okay?
understand. Thank you, sir.
All right, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step forward here to be fingerprinted with a bailiff. Make sure you leave with a copy of your order today. Okay?
Okay, thanks. I should believe that. This is for my excuse.
Yes, you have a jail this afternoon, correct?
We're still working on it. If that's not.
Okay. Mr. Stevens, are you ready or do you need time?
Actually, we're going to decide a jury waiver. And
Okay.
Bree said it perfectly, and I think she's putting me a waiver in
Okay.
now. Almost, Judge.
That's all.
Thank you, Your Honor.
Thanks, sir.
one for each one of you, or? Either that or y'all are gonna have to get me and Tonda a step stool for behind them.
Docket call today, and it's my understanding, Mr. Stevens, that your client wants to waive his right to a jury trial.
Yes, sir.
And you've explained to Mr. Egret that there's once he waives his right to a jury trial, there's only very limited circumstances in which that right can be restored to him.
Yes, sir, I understand.
And he understands that once he waives his right to a jury trial, he's also going to be waiving the right to confront witnesses and confront the state's evidence in front of a jury.
Yes, sir.
And you join in with your client in requesting the court to allow him to waive his right to jury trial.
Yes, sir.
The state does as well?
Yes, Your Honor.
All right, Mr. Egret, if you'll raise your right hand. Mr. Egret, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Egret, you can put your hand down. Mr. Egret, you've gone over this waiver of jury trial with your attorney, Mr. Stevens. Is that correct? Do you feel like you understand what waiving your right to a jury trial means? You understand that no one can force you to waive your right to a jury, but that's a right that is guaranteed to you by our United States and Texas constitutions. You understand that? And you understand that once you waive this right, it may not be restored to you. And you're asking the court to allow you to waive your right of jury trial and to set this case for a plea. Is that right? And has anyone threatened you, forced you, or pressured you, or otherwise made you believe that you had to waive your right to a jury trial? All right, the court hereby finds that the defendant has intentionally, knowingly, and voluntarily waived his right to a jury trial and has had the assistance of counsel, and the state consents to the same. So now it's a matter of setting it for plea, is that correct?
Yes, sir.
And do we need any certain amount of time?
Your Honor, just enough time for Miss Abney to do the paperwork.
Did it plea to time or plea to probation?
To probation, Your Honor. Judge, I believe we have a docket on the 20th, which would be next Tuesday, but the state is flexible to Mr. Stevens' availability.
Mr. Stevens, I have for the 22nd available if one's better than the other.
The 20th probably would be better for you, Your Honor. Would that be in the morning?
That would be in the morning.
Yes.
All right, then the court will set Mr. Egret then for plea on Tuesday, October 20th at 9 a.m. Do you have any other court conflicts that morning?
No, sir.
If we need to set it later, we can. We just need to have enough time.
I think I'm good, Judge. I'm supposed to have a trial with this.
All right, once Mr. Egret signs his notice of setting and receives the yellow copy, then he'll be free to go.
Approach on some housekeeping. Mr. Martinez's cases.
He's on his way.
Okay.
It says he'll be in about 20 minutes.
Okay, and then Mr. Kaufman, we set his assault family violence for jury selections. We also set his controlled substance. Did he bypass docket call on that as well? It is, yes.
Yes, court set each case for jury selection on 10/26.
And then on Mr. Stanley, did you assign him out to that NICI?
I haven't yet.
Okay.
Let's see, that's a first degree. Court will set it at 150,000.
Thank you, Judge.
Will you go ahead and call Ray Stanley? That's the
How
only.
long has he been in?
Since June 16th.
Yeah.
Yeah, it's past the 90 days.
Let me look. We don't have a case yet, so
Would you sign off on that?
most likely let me take a look.
Judge, maybe it's easy to take a call from Judge Shin.
Yes, ma'am.
A piece of paper. Said that you're charged, but
Just one.
it was a misdemeanor, but
One.
it was a plea, actually. I told Stephen the wrong numbers, and paperwork already shows 825 instead of. So I'm gonna make it.
we're ready on Mr. Vanderlinden. This is CR 20-93. And Mr., what are we doing again on Mr. Vanderlinden? Is this it right here?
Yes.
All right, Mr. Vanderlinden, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can put your hand down. All right, you are Christopher Vanderlinden, is that correct?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with?
Anxiety.
Are you currently undergoing any type of treatment or on medication for either of those?
Whenever I get locked up, I take medication, but I don't have them prescribed on the streets, man.
So you said that whenever you're locked up, you take that medication, but when
Yes,
you're
sir.
on the streets,
Yes, sir. Whenever I go to jail, yes, sir, I take my medication, but whenever I'm on the streets, I don't have it. No.
so you're not currently on any type of medication.
Yes, sir.
Do you feel like the fact that you're not on medication now has in any way inhibited your ability to understand these proceedings against you? You're represented by your attorney, Mr. Merleader. Are you pleased with his representation of you?
Absolutely.
Feel like you've had sufficient time to talk to him about your case and have all your legal questions answered?
Yes, sir.
Mr. Merleader, you believe your client to be competent?
Yes, Your Honor.
You've explained to him his legal and constitutional rights. Mr. Vanderlinden, you are charged by indictment with the third-degree felony offense of assault of a family or household member by impeding breath or circulation. However, the plea agreement before the court appears to be that you're going to plead guilty to a lesser charge of a Class A misdemeanor assault causes bodily injury of a family member. A Class A misdemeanor carries a range of punishment of confinement in the county jail for a period not to exceed 365 days or a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir.
It appears to me that the plea agreement is that in exchange for your plea of guilt, the state's recommending to the court that you get convicted of that offense, that your punishment be assessed at 149 days in the county jail with credit for 89 days, with you serving out the remainder of your sentence beginning on October 22nd, 2020 by 6 p.m., a fine of $3,500, court costs of $270, and reimbursement fees of $785. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Merleader?
Yes, Your Honor.
Then to the charge of Class A misdemeanor assault causes bodily injury, family violence, how do you plead?
Guilty.
Do you plead guilty because of the fact you are guilty?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Merleader, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor. Just for the record, I have spoken with the victim in this cause. And while there is not an affidavit of non-prosecution on file, she has notified me that she does not wish to proceed with prosecution. And that is the reason for the plea agreement that sits before you. We would rest in close, Your Honor.
Anything further from the defense?
Your Honor, I've counseled my client on the court costs and fine and fees that are owed to the county. The court accepts this plea, and he's agreed on a payment plan after talking with the county collections officer.
And you've counseled him on what happens if he doesn't pay?
Yes, Your Honor, the court will put out a warrant. I believe it's $50 per day to sit in the county, to satisfy those costs. So he understands. I've also explained to him that if he doesn't report, that could be an additional charge for him.
And all of his remainder of time will be served consecutively, is that correct?
Correct, Your Honor.
All right, then based on the evidence before the court and because it's the state's recommendation, the court will follow the plea agreement in this case. Court will convict you, Mr. Vanderlinden, of the Class A misdemeanor offense of assault causes bodily injury, family violence. Court assesses your punishment at 149 days in the county jail. The court awards you credit for 89 days of time already served. Assesses a fine in the amount of $3,500, court costs of $270, reimbursement fees of $785. Court orders you to submit yourself to the Van Zandt County Jail on October 22nd by 6 p.m. to serve out the remaining portion of your sentence. Court orders you to bring a valid photographic identification with you on that day. Your failure to do so will result in the jail not admitting you into custody, and your failure to appear on that day will result in the potential of a new charge being filed. Yes, sir. And Mr. Murder Leader has indicated that he's already counseled you on your obligations to reimburse Van Zandt County for the money that has been paid for your court-appointed attorney and your court costs and fines. Your failure to pay those will result in the court issuing a warrant for your arrest. All right, Mr. Vanderlinden, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step forward to be fingerprinted with my bailiff. After that, make sure you get a copy of your judgment so that you can submit yourself to the jail. Is that all you have until this afternoon, Mr. Mayor Leader?
Yes, I have a few cases of that, and I do apologize for being late. Told my client that if he's late for his reporting date, he'll be interviewed.
Thank you for staying on top of that.
Just curious, have we gotten time approved for trials?
Not just yet, but we anticipate we will for November.
Do you know which case possibly be?
That I do, but that'll be sent out later this week.
Here's one, let me go grab you the other. And let me print.
CR 19-181, CR 2054. I believe Mr. Martinez is set for a docket call today. What are we doing on this case, Ms. Heisel?
We have reached a plea agreement, so today we will be executing waivers with jury. Waivers and about the causes in place.
Yes, sir. All right, Mr. Martinez, I need you to raise your right hand. I'm going to place you under oath. Mr. Martinez, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Okay, make sure you speak up so my court
Yes,
reporter
sir.
can hear you. Mr. Martinez, in each one of your causes before the court, do you understand that you have the constitutional right to have a jury trial by a jury of your peers?
Yes, sir.
You understand that during that jury trial, you would have the chance to cross-examine the state's witnesses, confront their witnesses, cross-examine their evidence in front of that jury. You understand that? You also understand that you can waive your right to that jury trial, and only you can do that. No one can force you, pressure you, or deprive you of that right. You understand that? In this case, are you asking the court to allow you to waive your right to a jury trial and to resolve your case by way of a plea agreement?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to waive your right to a jury trial? And are you doing this of your own free will?
Yes, sir.
All right, the court finds that the waiver of jury trials have been entered in open court intentionally, knowingly, and voluntarily after having received the admonishments of the court. The court finds that the signature of Mr. Hyde, counsel for the defendant, and Ms. Heisel, counsel for the state, have joined in with Mr. Martinez in this request. The court hereby approves the waiver of jury trial in each cause. Do we need a specific amount of time for resolution, Mr. Hyde, for plea agreement?
Your Honor, dates are first of December.
Is there any reason we need that?
They set for a trial the week of the 16th. Obviously, the next week is Thanksgiving.
I got two dockets available next week, the 20th and the 22nd. Is there a reason that we need more time?
It's very general purposes.
November 3rd and November 5th. All right, court sets Mr. Martinez for plea on Thursday, November 5th at 1:30. And we'll report out at the Van Zandt County Justice Center. So once, Mr. Martinez, once you sign the white copy and get a yellow copy handed to you, then you'll be free to go. And we'll see you back on Thursday, November 5th at 1:30, not here in the courtroom, but out at the Van Zandt County Justice Center. You're free to go, Mr. Cruz. Once you get a copy of this yellow. Well, I appreciate you hustling over. He had been here since 9, so I didn't want to just reset.
County nurse gave all the employees shots yesterday. County, so now they're all
not good. All right, I believe that concludes this morning's docket. Ms. Heisel, is there anything else from the state?
You're on that document, have your name on, to address Mr. Ivy's issues, but nothing, left on today's docket or nothing needs to be on the road.
Okay. All right, then the court will stand in recess until 1:30 p.m. and we'll resume the criminal docket at the Van Zandt County Justice Center.